Yes, I'm Jay Wilkinson, and I've been a judge on the Federal Court of Appeals for the Fourth Circuit since 1984. President Reagan appointed me, and I think more importantly, I'm a father of two children, and just had my first grandchild not so long ago. Well, it's a job where you have to enjoy your own company, and you spend a great deal of time just reading briefs. But there are opportunities of bar meetings and symposia and everything to be sociable. It's not as monastic a life as some people think. You just have to sort of be careful about where you show up in a way that doesn't appear to commit you on a case, or that doesn't appear to anyone to be partisan. But basically, I think those in Congress use their ears a great deal to receive information. They're listeners in a big way at committee hearings and to their constituents and in floor debates, but their ears are very important to them. And I don't want to oversimplify the point, but judges, if you're a judge, your eyes are very important to you. You are reading all the time. You're just looking at one brief after another, reading one opinion after another, or reading one memo after another. I've hardly seen so many jobs that just involve more just reading. Doesn't mean, in oral argument you listen and you listen to your colleagues and everything, but we use our eyes as much as congressmen use their ears, and that's part of separation of powers. And maybe it's good that different organs of American government receive information in different kinds of ways. Of course, we listen and others read, but I'm just saying what I think a little bit of the emphasis is. Well, the main thing is it never stops. It's like waves beating on the beach. Litigation never takes a holiday. And there are periods where there are more cases awaiting resolution, and then there will be less. But you just never feel completely caught up. You don't ever. So maybe people in other businesses don't feel that way either. But you never. I can't remember ever saying to myself, "Well, here, I've done everything that needs doing." That doesn't happen. There's just always a checklist for tomorrow, and you never complete all the assigned tasks. There's always something else that you should do. Our docket is so varied, and sometimes I think we're among the last generalists. Alexander Pope, I guess, said that a little knowledge is a dangerous thing, but there's no way of avoiding the fact that we have to know a little about a lot of things. And it's sort of daunting in a way because many of the topics are so specialized, but there's nothing that we don't consider, really. I mean, law is intimately connected with life, and if there's a problem out there in life, it's going to find its way into a lawsuit, one way or another. There's no issue there that isn't going to eventually come in some form before the courts. That's not to say we try to wave a magic wand and resolve it for all of society. But we hear a large number of criminal cases. The more serious crimes tend to come into federal court. We hear a lot of labor cases. We hear a lot of major commercial contract cases. We hear occasional admiralty case. We hear a good many bankruptcy cases. We hear all kinds of civil rights cases under many, many different civil rights statutes. We hear lots of tax cases involving very complex provisions of the Internal Revenue Code. We hear cases involving pension rights under the statute that many people probably haven't heard of. It's called ERISA. We just, I know if there's going to be an event of the shock and magnitude of 9/11, then that's going to produce some litigation. And if you have something on the that comes up, such as the tragic affliction of AIDS, that's going to result in all kinds of new problems and litigation. And if you have this rapid expansion of technology on the internet, then you're going to have a whole set of protocols and rules to deal with in terms of that. So we have jurisdictional rules, but between federal question jurisdiction and diversity jurisdiction, we're going to hear most anything. Well, you do. You try to read on a need-to-know basis. You have to realize that you're not going to be able to understand or know everything. And if we're not specialists in one little thing or another, we are specialists in law, and it's sort of that toolkit that we carry into every case, a set of it's legal equipment that recognizes patterns in questions that occur across fields. And you might think, well, what would this and what would A and B possibly have to do with each other? They're apples and oranges. But no, common problems emerge. And so there's a factor of recognition that helps you to deal with these very disparate subject matters. And the other thing is you train yourself to try to become a quick study, when you get into oral argument, which is very important, you really get to ask questions that you need to know. And I'm not afraid of asking somebody to explain something to me on a very basic level, and they may think, oh, well, this judge is just miles behind me in terms of my understanding and my sophistication about the subject. But it will do them good to explain themselves in basic terms. They need to be able to leave their arcane worlds and express something to me in a very basic way that will let me understand what's going on and try to resolve the case. And maybe that's something people need to concentrate on a little bit in this age of specialization. You can come up with a very complicated problem, but sooner or later along the line in litigation, you're going to need to explain it to people that haven't lived with it their whole lives.